Hi, my name is Charles Capouet, and I'm an associate at Eversheds Sutherland and member of the state and local tax team. And with me today is another member of the SALT team from the New York office, Chelsea Marmor. On behalf of the SALT team, we hope you enjoyed reading the latest edition of the 2018 Year in Review SALT Scoreboard.
Throughout 2018, the SALT team tracked and tallied significant taxpayer wins and losses, analyzed those results, and gave you updates in our quarterly publications. And the 2018 Year in Review is the first to be published in Tax Analysts.
Our last videocast came after the second quarter of 2018. At that time, taxpayers had prevailed in only about 34% of cases. So, since we've reached the end of the year, Chelsea, have taxpayers bounced back from those early losses?
They have. In the second half of 2018, taxpayers prevailed in 39% of their cases. That brings the year-end total up to a total of 37% of 220 cases.
In comparison with prior years, first, in 2016, taxpayers prevailed in 43% of 223 total cases, and in 2017, taxpayers prevailed in 41% of 239 total cases. So, among these 3 years, taxpayers had about the same amount of significant cases, but they fared a little bit worse in 2018.
Now turning to cases by tax type, taxpayers prevailed in 33% of significant corporate income tax cases and apportionment tax cases. Taxpayers prevailed in 38% of significant sales and use tax cases, and taxpayers prevailed in 47% of manufacturing exemption cases.
So now that we're at the end of the third year of the SALT Scoreboard, were there any states in 2018 where taxpayers were more or less successful than others?
There were a few states taxpayers did better, including Louisiana and Ohio, where taxpayers prevailed 40 and 47%. However, taxpayers did not do as well in California and New York, where taxpayers only prevailed about 31 and 32% of the time.
It seems like taxpayers had a harder time in 2018 than in prior years.
They did. There were numerous interesting cases this quarter. For example, Energy, a case tackling the application of retroactive amendments to New York's Empire Zone statute. There was also Richardson's RV versus the Indiana Department of Revenue, which analyzed whether sales that consummated in Michigan were subject to Indiana sales and use tax. There was also Targus Resources Partner. This was a case out of the New Jersey Tax Court, which analyzed whether the partnership filing fee violated the U.S. Constitution. Charles, were there any cases that you felt particularly interested about this semester?
Sure. In Canon Financial Services v. New Jersey Division of Taxation, the New Jersey Tax Court held that the 5-factor apportionment formula could not be imposed by the division on a taxpayer. The tax court concluded that it was a violation of the Administrative Procedures Act as it was an invalid rulemaking. Originally, on audit, the division rejected the taxpayer's use of the traditional 3-factor formula, and instead said that the taxpayer should have allocated 100% of its income to the state. But later on, the division issued a revised assessment, which instead used a 5-factor alternative apportionment formula. That alternative formula split the property factor into 2. Ultimately, the tax court said that the division could require use of the 5-factor formula, but its discretion isn't boundless. Instead, the division should have issued a regulation under the formal rulemaking of the Administrative Procedures Act, rather than having a mere audit change.
2018 was a really exciting year for state and local tax. Thank you for watching our 2018 Year in Review. Be on the lookout for our 2019 editions. If you have any questions or want to know more about the SALT Scoreboard or the SALT team, please visit eversheds-sutherland.com, stateandlocaltax.com, or the SALT Shaker app.